Out there, K County Accountability, coming at you guys with a few things tonight. Article popped up that I wanted to address. The fact that I brought up in another video that it seems that if you're a decently attractive female, which guys don't try to say I'm saying this woman's hot, blah blah blah. No, she's decently attractive. She's not a fucking tweaker like majority of the people you see arrested and shit. You know, pockmarked, fucking sunken face and all that shit. This woman's not. She's decently attractive. And she got a dismissal. If you read the article, I mean, they had her fucking dead to rights. I don't give a shit. That woman was guilty. But for some reason, you know, and it only took them 6 months to dismiss this. I've been going on fucking 2 years now. And also, guys, in fact, tonight I heard from Jared Stevenson, which he's trying to be my attorney, but I've told him, you know, no, I'm sorry, but I'm guaranteed the right under Oklahoma State Title 30. And yes, Title 30 is guardian and ward. Okay, yes, that's what Title 30 is. However, subsection 30-3-107, appointment of counsel, explanation and inquiry by court, replacement of appointed counsel, determination of independence of retained counsel, Section G, in all cases where independent counsel is retained by or on behalf of the subject of the proceeding, the court shall make independent inquiry. Anyways, guys, this applies to everyone. And Jared Stevenson seems to believe that only, you know, it only applies in guardianship and ward. No, it applies to anyone. They are under the Sixth Amendment and under Oklahoma state law, they are guaranteed a proper defense, which you won't give. You have, and guys, I have text messages, which I'm going to put into a different video with Jared Stevenson. He's an absolute fucking moron. Okay, guys, and then I also want to touch on the fact that I found an Oklahoma state law, which it also goes off of Rule 2.11 of the Judicial Conduct Code, of what all judges are required to follow and stuff. All right, guys, let me read this, where Judge Wilkie has been violating, you know, not only this law, but also Oklahoma disclosure laws. He is required to disclose that he was a former employee of Brian Hermanson, which I have confirmed that Judge Wilkie, David Wilkie, was appointed as a judge either February 17th or 19th of 2019. Okay, Marley Thornton, the court clerk or whatever, that's best information I can get. The DA's office is refusing to give me, unless I come and put in a public records request, the times and dates of his employment with the DA's office. Which is, I mean, just, it's fucking ridiculous. That should be actually out there to show the public, you know, transparency that, hey, you know, one of our judges actually, his boss is the DA, you know, so blah, 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 you know. Anyways, let's talk about this. A judge shall disqualify himself or herself in any proceeding in which a judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. 1. The judge has a personal bias or prejudice concerning a party or party's lawyer or personal knowledge of facts that are in dispute in the proceeding. The judge knows that the judge's spouse, a member of the judge's household, or a person within the third degree of relationship to any of them or the spouse of such a person is A party to the proceeding, or an officer, director, general partner, managing member, or trustee of a party, acting as a lawyer in the proceeding. C, a person who has more than a de minimis interest that could be substantially affected by the proceeding, or D, likely to be a material witness in the proceeding. 3, the judge knows that he or she individually or as a fiduciary, or the judge's spouse, parent, or child, or any member of the judge's household has an economic interest in the subject matter in controversy or is a party to the proceeding. 4, the judge knows or learns by means of timely motion that a party's lawyer or the law firm of a party's lawyer has within the previous 4 years made aggregate contributions to the judge's campaign. Basically, if you give money to the campaign, a certain amount, they have to, you know, recuse themselves. But I want to get down to, let's go to here, 6, the judge. A, served as a lawyer in the matter in controversy or is associated with the lawyer who participated substantially as a lawyer in the matter during such association. That is, him being a prosecutor for Brian Hermanson, which is in the fucking courtroom. Served in governmental employment and in such capacity, participated personally and substantially as a lawyer or public official concerning the proceeding, or has publicly expressed in such capacity an opinion concerning the merits of a particular matter in controversy. C, was a material witness concerning the matter, or D, previously presided as judge over the matter in another court or any judiciary capacity. B, a judge shall keep informed about the judge's personal and fiduciary economic interest, make a reasonable effort to keep informed about the personal economic interests of the judge's spouse, members of the judge's household. A judge subject to disqualification under this rule, other than for bias or prejudice under paragraph A1, may disclose on the record the basis of the judge's disqualification and may ask the parties and their lawyers to consider, outside the presence of the judge and court personnel, whether to waive disqualification. If, following the disclosure, and parties and lawyers agree without participation by the judge or court personnel that the judge should not be disqualified, the judge may participate in the proceedings. The agreement shall be incorporated into the record of the proceedings. Here we go. Approved by order of the Supreme Court, 2010, Oklahoma 90, effective 4/15/2011. Under this rule, a judge is disqualified when the judge's impartiality might reasonably be questioned regardless of whether any of the specific provisions of paragraphs A1 through 6 apply. Meaning, yes, his impartiality is in question because his former employee is the fucking DA. And every fucking assistant district attorney is either his former co-worker or works for his former employer, which right here it states he has to remove himself. A judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. Like, this is absolutely ridiculous. And not only the disclosure laws that they have been absolutely violating. And I talked to the AG called me today. I've been waiting since last week for him to call me. Talking to him, I explained the situation, and he actually sent me in my email, if anybody wants this, it's a complaint form for the AG's office, which I push that anybody and everybody fill this out also. So if you want one, either contact me on Facebook, put your email in the comments, and I'll email you this PDF, and you can just print it off and fill this out and send it in. We need to do as many as possible. We need to get fucking Judge Corrupt-Ass Wilkie the fuck out of goddamn K County. So guys, take care out there. Always film the police. And please, let's get these complaints in. It's the only way we're going to make change and get rid of this rigged, corrupt K County system. You guys take care.